It is not ideal to start a stream and then stuff your face full of gummy lollies. I really feel like that didn't actually work. So, hey ho, folks. Hope you're doing well. I'm just gonna finish chewing on the gummies and then turn the camera on. God, that must be some amazing ASMR for you guys. So, welcome to my humble abode for the evening. Decided to stay the night. No one's here. I'm driving to Melbourne as you listen. Well, I mean, the least you here for the. God, it has been so long since I've streamed off this laptop. I've got to remember where the camera is and how it works. But on the upside, I decided to stick around work for the night so I can actually get a half-decent night's sleep for once. And don't have to do the 4-hour driving at least, so it's removed a little bit of that. I still have to drive back tomorrow, obviously. But on the upside, means that we've got 2 hours where I can just talk to you guys without having to be focused on the road, and I can actually discuss stuff, which doesn't really happen a lot these days, so... But things I've learnt so far. I think that the streams are going to go significantly better when we're doing the camping, because although the motel has internet, there is not sufficient space to have the Starlink set up. Like, because you know, in a hotel you can just sort of stick it on the window and you'll still get reception, you'll still get a half decent signal. You kind of forget that when motels are all sort of single story, they have like awnings and crap, and this one's like got a whole bunch of trees out the back and stuff, so it's really blocking the connection. So currently I'm burning through the battery on my mobile phone to use my mobile data. Shh, don't tell Lady Overlaw'd. But fingers crossed it makes a little bit of difference. So the room's sort of what you'd expect, just for the price sort of thing. So don't worry, you're not going to see anything like untoward or anything. So Goat Boys in the chat. I'll be honest, Val, I was scrolling through like an hour or two ago, and I was like, holy crap, why does the Goat stream have 100 and something people watching? I was like, oh shit, you're on Bakewell there. Okay, yeah, that makes sense. Oh. Hello, maybe not. You can do like Elon and sleep in the office. The building is over 100 years old. Call me crazy, but I don't really want to sleep there. Not because of ghosts or anything like that, but because I'd be worried about my health and well-being. As it is, I have a air purifier on in my office pretty much daily because they've still got files in there from the early 1900s that are just decomposing, and I'm sure it's not doing any good for my health. So, but anyway, so let me just use what limited internet capacity I have here. Let's have a look, see what we've got. Yes, it's going to be fairly boring, but at least you've got me to look at this time around, and I can actually talk to and respond to you in real time without having to worry about the chat. Documents aren't going to hurt you. Little minute particles of dusty 100-year-old ones, mate. I'm camping out for tonight. Not tonight. Tonight and next week, I am going to be in a hotel. Mainly because next week I'm bringing Little Lady Overlaw'd with me. And, like, camping with her, I'd be worried. So, yes, it is Attack of the Goats. Slays all day. So, I mean, the main thing that I've seen crossing my feed was the whole tariffs thing, but let's face it, we try not to... who kidnapped me? I kidnapped me. I still don't... I had this exact same conversation with Lady Overlaw'd this morning. Why are people still surprised that the President of America is putting America first? I mean, in most cases, the tariffs are reciprocal. Australia charges 10%. So we're getting slammed with 10%. Makes sense to me. Catalina was evicted from the birthing stall. Give Aussie a thumbs up in protest. Wait, what? White gloved super old documents, they won't hurt you. Because the world is used to being forced to give our money to everyone but America. That is fair. That is fair and understandable. Oh, I tell you what was really interesting, though. I didn't realize it until people started posting it on X today. About a decade ago, Anthony Albanese, Australia's Prime Minister, made a made a oh, you know what? No, let me just see if I can pull it up. Hang on. Bring up something visual, shall we? Michael Douglas. Surely that'll bring it up. There it is. Oh, and that is very friggin' loud. I suppose it's probably because I'm used to being in the car. Let me pull the audio down for me at least a little bit. Or is it actually on this? Might be actually on that. Present, share screen. Like, the little reject actually makes a word for word. He just stole it from the movie. His entire speech.
Challenges to solve, and we need serious people to solve them. I promise. Unfortunately, Tony Abbott is not the least bit interested in fixing anything. He's only interested in two things: making Australians afraid of it and telling you who's to blame for it.
I just think that Michael Douglas was much better at it than Albo.
All credit to Milk Bar TV, because I did see that, for example, Sky News and a few other places were stealing some of his stuff and not bothering to mention it. But, am I sleeping over? It's not fun commuting? No, the commute was starting to get to me, I'm not going to lie. I was starting to get very run down. So I'm hoping that by doing this once or twice a week or a fortnight, something like that, even just having a day where I'm not doing the massive drive. In school, we call that plagiarism. Hello, Cinderlocks, not usually awake this time. Well, thank you for being here. Very much appreciate that. Well, you don't need to comment on the fact that Douglas isn't his real last name. We're commenting on the fact that Albanese isn't Albanese's last name. So for those of you that don't know, Albanese's mum got knocked up by an Italian guy on a boat, and because she was Catholic, obviously, you know, had to go through with it. But the Italian guy just stayed on the boat and just sailed away, apparently. Allegedly. From what I've read. So. Damn. When I drop the quality on the camera, it really doesn't look great, does it? Was he staying in the red light district now? No, not so much. Let me see if I can fix the... I suppose you don't really need to see how bad... Oh, that's... It's because there's a single light above me. It actually does look like a... what do you call it? Like a hostage video or some shit like that, doesn't it? Alright, where are we? What else have I got that I've missed? I'm trying to go back to the good old days of when I actually covered Australian news stories, like we talked about last few days ago. But, I can't tell if that's actually updating or not. I'm assuming not. Looks like you're in a prison colony. Well, it's kind of what it feels like. I'm not gonna lie, I don't think I'm gonna come back to this motel. Like, the people were nice, but especially for the price, I don't believe it was worth it. I would much rather have the peace, tranquility, and the comfort of my own car, ironically. So, feel claustrophobic just looking at the room. Will it make you feel better if I move? Hang on. God, these chairs are so uncomfortable. There, is that better? A bit better? Doesn't look quite as claustrophobic. Have I seen Meme Copium's dino streams? He could use a dino body. I've seen him do some of the crocodile ones. I don't know. I mean, is it even a multiplayer game? I got no clue. I don't know how that works. So, I thought it was that thing that you have to whisper. I don't think the walls are particularly thin. I mean, looking at them, it looks like they're concrete. I don't know how soundproof they are. So, Canada Trump tariff exemption, like dodging a bullet in the palm of a tank. New South Wales Drug Summit urges government to scrap sniffer dogs and strip searches at festivals. No shit. I wonder why you should think about doing that. Like your take on politics. Love to hear your take on politics. Well, I try. It's multiplayer. Oh, there you go. Well, I mean, the trouble is that when I get a bit too political, that's generally when YouTube starts getting a little bit pissy at me. So I've only really just started being a little bit more liberal, not that kind of liberal, in terms of how I put my views out there, shall we say. Australian stocks slide as Trump's tariffs shock the global markets. Well, I'll read that one later, but not going to wall and see if someone knocks back. No. I'll be honest, Cairn is a lovely little town. But this is probably the least comfortable I've been in the town before. And that's honestly, that's saying something. Counterfeit Ozempic products have been detected. Don't really care about that. Scientists collecting unique sea creatures during voyage to East Antarctica. You know how horror movies just keep becoming like documentaries? You'd think they'd leave shit alone like that. As we need like the Thing or something to be coming along. Machine learning helps construct an evolutionary timeline of bacteria. Thanks. 35-year-old millionaire offends struggling Aussies. Oh, no shit. Tornadoes in Mississippi and Tennessee this evening. Stay safe. Yes, please, by all means, stay safe. That sort of shit's always scary. G'day, Chris. Crypto. I feel like I'm going through and flicking on switches in rooms in my house that I haven't been in ages. Like I'm going through back through my old news aggregators and various other things for what I used to actually do for stuff before I got lazy and just used a single one. DDoS attack now dominant means of waging political cyber warfare. Mark Ronson rushed to A&E. Don't care about that. Don't even know who Mark Ronson is, nor do I care. Don't fall for shirtless Musk with large gut holding leash at beach. Is someone actually posting shit like that? Like, seriously? Ideally, what I should be doing... Oh, hang on. Wasn't there a motions hearing or something that I'm behind on? Because I was going to say, ideally, I would have had the Zach Hughes trial queued up and ready to go. Because I know that they had videos for the Judging retrial, delivering instructions on second day of jury selection. Really? Is that all it is? Jury selection underway. Oh, that's interesting. Did they change courtrooms? Or was it just for that day? Norfolk's period caught up with first day jury selection. Oh, I mean, I suppose we've got all the court documents that I've got to go through too, don't we? Post archives, that's not really the one that I want. Court listener, that's the federal one. Wow, sorry guys, this is even more boring than my driving streams. Holy crap, I am out of practice. Okay, what's that? Motion in limine to preclude reference to and redact the manner of death from the victim's death certificate's been denied. I should bloody well hope so. How caught up am I on Karen Reid, judge having a moan because someone criticised her? Oh no, really? No, I'm very much behind on various bits and pieces with that. That's why I'm sort of having a look now. Oh, I did see that Randazza put in a federal free speech case against Canone, though. I was not expecting that. But holy shit, am I here for it? I can't wait to see that one get all up in our ass. Memorandum of decision and order on Commonwealth's motion limited to exclude defence expert Michael Easter's opinion of investigation. This one I want to read. All right, hang on. All right. That doesn't really help, does it? I suppose that's a bit then. Although now I can't see the screen. All right, doesn't matter. Defendants have the right to base their defence on the failure of police to adequately investigate in order to issue a reasonable doubt as to the defendant's guilt in the mind of the jury. That's fairly straightforward to me. To support a so-called Bowden defence, a defendant must present evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about the suspect was not investigated in circumstances which it was reasonable to expect the police should have conducted such tests, followed such procedures, or investigated such information. You're on the right track so far. Oh, because you're quoting the evidence guides. An expert may, when appropriate, be used to support a Bowden defence on matters beyond the common knowledge of the jurors. Considering whether counsel's failure to use a forensic expert to testify about powder residue and measurement of bullet trajectories deprive the defendant of a chance to assert defence. The role of the expert testimony is to assist jurors in interpreting evidence that lies outside the common experience. Yeah. Thus, the first foundational element that the proponent of the expert testimony must establish is that the testimony will assist the trier of fact to understand the evidence or to determine the fact in issue. Otherwise, qualified expert testimony is admissible if, in the judge's discretion, subject of that such testimony is not within the common knowledge or common experience of the trier of fact. The testimony will assist the trier of fact in determining a fact in issue or in understanding of evidence. In support of the defence, the defendant here seeks to admit expert testimony from Michael Easter, retired agent for the FBI, to opine on law enforcement's failure to adhere to standard investigative policies and protocols in the case. More specifically, the expert report indicates that he will testify that the investigation in this case was not reliable due to lack of secure crime scene, absence of detailed crime scene or log, absence of a detailed crime scene log, or evidence chain of custody, the failure to separate witnesses, the premature characterization of witnesses as individuals, and potentially bias based on failure to investigate other suspects and obtain their cell phone records. The court cannot find, nor has the defense counsel cited one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. Huh? Is she freaking serious right now? Hang on. I'm sure. No, hang on. She has to be lying through her fucking teeth. FBI investigation into Karen Reed's case was never closed. On March 20, 2025, it was disclosed to the Commonwealth for the first time and in open court that Attorney Yannetti had received federal subpoenas from the United States Attorney's Office to produce his entire case file. On March 25, so the federal investigation is still ongoing. March 25, 2025, the Commonwealth was informed that discovery produced to the defense. Holy shit! So the federal case is still going on. God, she just looks like such a cow. I was positive that when it came out that I saw someone was talking about case law, and I want to say it was someone that Andrea Burkhart replied to. Collins doesn't want defense expert and former FBI agent to tell the jury how badly the police failed in their investigation into the death of Officer John O'Keefe. Saying that there's no case law, that I refuse to believe that that's accurate. Okay, anyway, you know what? Doesn't matter. Oh, crap. That's how out of touch I am, people. I literally just closed the page that I was trying to share. God. No, Tammy. You know that the feds are still investigating. Never thought they would say what was happening. No, I wasn't expecting the feds to say what was going on in the course of their investigation. I was not expecting anyone to confirm that it had been closed as early as they alleged that it had. That was always bullshit to me. All right, an expert may, where appropriate, be used to support a Bowden defense on matters beyond the common knowledge of the jurors. The role of expert testimony is to assist the jurors. Thus, the foundational element will assist the trier of fact in support of. Got that. The court cannot find, nor has the defense counsel submitted one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. The defendant cites the Commonwealth v. Wood, where the Supreme Judicial Court noted the defense counsel, through cross-examination and the calling of its own expert, extensively challenged the adequacy of the forensic investigation conducted by the police. The court acknowledges that some forensic matters are beyond common knowledge of jurors and therefore appropriately explained by expert testimony. That is not what the defendant is seeking to present through Easter's testimony. You bitch. So basically what she's saying there is that the proper conduct of an investigation by police officers is something that a layperson juror should understand and be within their knowledge. So she's either saying that it was so clear that the Canton PD breached their requirements and their protocols and procedures in doing an investigation, or more likely, she's just going to say, well, it's up to individuals to determine whether or not they believe that a investigation was conducted properly or not, and we don't need someone from the FBI saying, no, this was pathetic. Lack of authority suggests that during all jury trials where the defense has been inadequate police investigation based on Bowden, expert testimony has not been needed for the jury to be able to evaluate the reliability. Commonwealth's case and whether any failures of investigatory steps are sufficient to create reasonable doubt in the defendant's guilt. East's proposed testimony concerns basic aspects of police investigation which are within the common knowledge of a layperson. Quite literally, she's expecting the defense to get up there and ask each of the police officers to say, was this investigation conducted properly? Do it. Through zealous cross-examination of police witnesses, the defendant can cast doubt on reliability of the investigation by demonstrating how it differed from standard practice and procedures, and can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. That's a crock of shit. There are multiple things that we are aware of now that the police did or did not do at the time that are better. Considering the jury spoke out, said it would be good to have an expert to explain what they did wrong. Exactly. Probably part of the reason why she said, no, we're not doing that. Hang on one sec. Ugh, sorry, I had to reach for my drink and I didn't think you guys needed to see that. That's not bad. I got some local apple and black currant juice. Data defense supported by testimony elicited from police investigators that did not conduct criminal history check on a third party, waited a week to interview him and conducted an interview for only 10 minutes. Or per Finney, reports would have been admissible to show the police were on notice of a third party of a potential suspect, but that he was not investigated. The court finds that expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow and evaluate the adequacy of the police investigation in this case without the assistance of expert testimony as proffered by the defendant. Fuck you, Bev. As usual, loading the deck and... Sorry, was it? No. Cutting the deck and loading the dice in favor of the... Would you say that you gave it a whirl? I'll show myself out. Yes, you show yourself out. Exactly. When the cops get asked, they're going to minimize it all. Exactly. Of course they're going to. As if any of them are going to get up there and tell the truth about it. As it is, Proctor's going to get up there and basically not answer questions. He has no reason to protect himself now. Well, no, that's the wrong... He's got no reason to answer in a certain way because it's not like he's going to be trying to protect his job anymore. Remember during the trial when the lead cop didn't know how the evidence bag tape worked? Alright, what else have we got that I'm missing out on here? Defendant's response to Commonwealth motion to exclude Garrett Wigg. Oh, that's right. Didn't she allow their expert, though? Lieutenant Garrett Wigg as a Sir rebuttal expert to Commonwealth expert witness Dr. James Crosby. In actuality, the defendant intends to call Lieutenant Wing as an expert witness in her case in chief and not as a rebuttal witness to Dr. Crosby's testimony. On this basis alone, the Commonwealth's motion should be denied. Yes, it should. As the defense has stated previously, on 18th of June, the court determined that only a medical doctor could opine on a medical cause of injury to a human. Until March 6th, the defense therefore operated under the impression that only medical doctors were able to testify to the medical causation of the injuries to humans, including injuries caused by dog bites and claw marks. This court's order on March 6 caused the defendant to revisit the topic of the wounds in the right arm of the decedent, including potential witnesses expert in dog-inflicted wounds on humans who were not medical doctors. At no point did the defense ever express that Lieutenant Wing was intended purely as a rebuttal witness for Dr. Crosby. Dr. Wiltshire. After review of the parties' submissions and consideration of the 5 Daubert factors, the court concludes that there is no reason to preclude the testimony of Dr. Wiltshire outright. Dr. Wiltshire has the requisite education, training, experience, and familiarity with the subject matter to qualify him as an expert. And his report demonstrates the methodology or theory underlying the expert testimony. Are you fucking kidding me? That's the guy that made his own thing up. And that, as far as I'm aware, is not repeatable. Defense raises several challenges to specific slides provided by the Commonwealth in support of Dr. Wiltshire's anticipated testimony. His expert report accompanying the slides, however, indicates the information methodology relied upon in forming his opinion. To the extent the Commonwealth seeks to elicit evidence that the defendant believes is beyond the witness's field of expertise, is not supported by methodology that is commonly accepted or relies improperly on witness statements, defense counsel can object to the line of questioning at trial. Fuck you, Beth. They shouldn't need to. He is not an expert in the field. That's crook shit. Memorandum of law in opposition to Commonwealth's motion to eliminate preclude defense from raising third-party culprit. Well, I'm not going to harp on about that because I know that they allowed 2 and they left out Colin, which shock horror. I believe that he's more involved than anyone has at any point let on. They wouldn't have tried so hard to hide the fact that he was at the house, which I'm sorry. You can tell me as much as you like that you don't think he was. I call bullcrap. So, not sure why Lauren Crime's link is now private. Oh, okay. If you ran him over in the driveway, how did he end up by the flagpole? Because he flew 30 feet in the air. Turtleboy's motion protective order regarding the sharing of cell phone data between the prosecutor and the lead prosecutor. She denied Turtleboy's exemption so he could report on the trial. Of course she did. I'm guessing that the motion for protective order got dropped as well. Combined witness list. Oh, okay. All right. So let's have a look at the witness list. So this is the up-to-date combined witness list. So we've got Turtleboy, Isaac Wolf, MD, Alfred LaPladio. Oh, look, Alison McCabe. That's going to be fun. Frenchler, Albone, Charles, Bell. Both Brian Alberts, Brian Higgins, Brian Bridget, Caitlin Albert, Charles Ray. Oh, look, the police chief's on the list. Yay! Crawford, Colin Albert's still there, Courtney Proctor. Oh, they're going to put Courtney Proctor on the stand. That'll be funny. Rand Paul was preaching that tariffs are taxes without representation. God help us. What the fuck? What? Okay. I think I'm okay scrolling through this particular Reddit sub because I can't imagine that they're going to... I mean, as far as I'm aware, Proctor never found any nudes on her phone, so I don't think there's going to be anything that's untoward on him. Defendant's response to redacted presentation of witness. 11 pages? Jesus. And that was on the, what, the 120... Oh, well, hang on. How many pages of that is exhibit? Sorry to anyone that's getting a seizure. Defendant identified numerous defects in the proper testimony of the proposed Commonwealth expert, given the magnitude and obvious nature of those defects, including a lack of cogency and even clarity related to his methodology. And she still let it in. Fucking hell. Variant decision on order of motion limiting. How many pages is that? That's only 4 pages. Okay. Commonwealth was moved to preclude the defendant from raising a third-party culprit defense. I mean, that was a very fucking low bar. The fact that she even let Colin Albert off for that, I think, is honestly pathetic. Opportunity for third-party culprit defense evidence is guaranteed by the Due Process Clause of the 14th Amendment because it's rooted in the right to criminal defendants to a meaningful opportunity to present a complete defense. The defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity to commit it. Good job she started on April Fool's Day, I know, right? Defendant may introduce evidence. However, the defendant's latitude to introduce such evidence is not boundless. The defendant's ability to mount a third-party culprit defense is not without limits. Evidence that a third party committed the crime charged against the defendant or had the motive, intent, opportunity to commit the crimes is admissible, provided that it has substantial probative value and will not tend to prejudice or confuse the jury. Proffered evidence must have a rational tendency. As to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, or opportunity to commit the crime. Oh, and opportunity to commit the crime. The evidence of opportunity is wholly inadequate. There is no evidence that Colin Albert was at 34 Fairview with the defendant and Mr. O'Keefe when the defendant and Mr. O'Keefe arrived at home. Aside from, wasn't it Ali McCabe on the stand saying that he was there? Okay. Third-party culprit evidence properly excluded where there was no evidence third party had means or opportunity to commit crime. Evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived. As to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans at O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims in the first trial. Even if there was evidence of some ill will between them, motive alone is not enough to demonstrate third-party culpability. Moreover, the theory that Colin Albert is the third-party culprit because he had scraped knuckles at some point after O'Keefe's death, had been seen in a video drunkenly taunting others with no connection to O'Keefe, and apparently was not named in police reports is speculative at best. Wasn't there text messages that proved he was there? There was some, in my opinion, doctored text messages. In fact, I think I only saw them this morning. It's the ones where it showed that the text messages had come in after midnight, allegedly. And so the next date, which triggers off, hadn't actually appeared. So it seemed pretty damn obvious that had been doctored. So... allowing such feeble third-party culprit evidence poses a risk to unfair prejudice to the Commonwealth and would only serve to confuse the jury. Accordingly, evidence that Colin Albert is the third-party culprit is excluded from trial. Brian Higgins and Brian Albert. As to Brian Albert and Brian Higgins, the defendant's proffer is barely sufficient. Fuck you. And the history of the first trial casts doubts on the seriousness of the claim. Fuck you. However, to protect the defendant's right to a fair trial and in recognition of the fact that the defendant had no burden to prove anything under law. So if the defendant has no responsibility to prove anything under law in order to the third-party culprit, how can you say that it's barely sufficient. That doesn't work. The court will take the same incremental approach as it did in the first trial. Defense counsel ordered not to mention potential third-party culprits in opening, but counsel will be allowed to develop the evidence at trial if possible. Fuck you. And counsel may seek an appropriate instruction if warranted if the evidence is concluded. So she's leaving it vague and open to her interpretation as to whether or not... God, that is so wrong. The court may ultimately exclude the proposed third-party culprit evidence, or counsel may abandon the theory. That does not mean the defendant cannot offer the evidence to show the inadequacy of the police investigation, provided the proper foundation has been established. Alibi McCabe. I like that one. That's good. Hereby order the defendant is precluded from raising third-party culprit defense alleging Colin Albert's culpable of trying to keep death. The Commonwealth is allowed. Commonwealth motion is allowed. Okay. The audit team review... Okay, so this is part of the audit of the Canton Police Department. The audit team reviewed a series of crime scene incident reports spanning over a decade. While some investigations found to be in line with established guidelines, there were cases of policy breaches mainly relating to the use of digital photography for documenting crime scenes as required by Canton PD's evidence collection and preservation policy. Additional shortcomings were identified in the areas of crime scene preservation. No shit. Detailed incident documentation. Our evaluation included a detailed analysis of the Canton PD policy and procedure with specific focus on evidence collection 601. Okay. During the examination, the audit team, which should not be conducting their own audit. If you do, Sherry, feel free to flick it to me at AussieOverlaw'd@gmail or just on X. Either way, I'm more than happy to take a look at that. During the examination, the audit team assessed the response from crime scene procedures carried out by Canton PD involving the tragic death of Boston police officer John O'Keefe. These actions were compared against existing policies, regulations, and requirements to determine compliance. The review of this major incident encompassed crime scene investigators, police reports, evidence, policy violations were identified below and in the final report. First responding officers should have photographed Boston police officer John O'Keefe at the location where he was found before the fire and rescue moved him to the rescue. All interviews of critical witnesses, including Jennifer McCabe and Kerry Roberts, should have been conducted by Canton PD on January 29, 2022, after John O'Keefe was transported to the hospital. Consensual recorded witness interviews should have been conducted. State Patrol, along with Canton PD, should have maintained a police presence at 34 Fairview, pending the secondary search conducted by MSP crime scene units. All video footage files maintained by the Canton PD's police computer system of Karen Reed's Lexus SUV, while it was housed at Canton PD, should have been requested and turned over early in the Karen Reed case to lead investigators for any action as deemed appropriate. How much do you want to bet that this report does not in any way, shape, or form find its way into the court case? Canton PD detectives did not have access to evidence collection kits in Canton PD vehicles to secure the blood evidence located near the body of Mr. O'Keefe. Canton PD detectives stated that they only utilized solo cups as a last resort to preserve the forensic evidence until it was transported to the MSP crime scene forensic unit. Oh, I don't know. I call bullshit. Because aren't these collection kits supposed to be in each and every car? More to the point, couldn't they have called the station and said, hey, we need a forensics kit? The audit team found Canton PD did not follow policy and procedure related to evidence collection and preservation. The audit team found that there was no Bureau of Criminal Identification units initially on scene, nor were crime scene kits available or used for evidence collection. According to the crime lab, plastic is not recommended for packaging or storing moist or wet evidence items due to the acceleration of decomposition of biological material on the evidence. Notice how that's like italicized instead of like bold. No photos were taken of John O'Keefe at the exact location where his body was found. Canton PD officers used personal phones to photograph and video the evidence collection at 34 Fairview. Pursuant to Canton PD, a digital camera or laptop computer should have been used to photograph the crime scene. Canton PD first officer on the scene should have photographed John O'Keefe where he was found before he was moved. Jennifer McCabe and Kerry Roberts should have been interviewed, and the interview should have been recorded at Canton PD after Mr. O'Keefe was taken to the hospital. Both witnesses accompanied Miss Reed and drove with Miss Reed to 34 Fairview. Nicole and Brian Albert should have been interviewed at Canton PD. That sentence should be filed under no shit Sherlock. How well the laptop pictures turn out? Look, probably not great, but it's still more appropriate to pull one of the laptops out of one of the cruisers and use that as opposed to a personal phone. Both the State Patrol and Canton PD failed to maintain a police presence to maintain the integrity of the crime scene. Both agencies should have coordinated to have an officer maintain presence pending the secondary search. The audit team found that there were incomplete coordination requesting all video files to the custody of Canton PD regarding the Sallyport camera. The video was maintained from January 29, 2022 through to February 2, 2022. All video files maintained, all sounds at Canton PD should have been requested and turned over early in the Karen Reid case to lead investigators for any action deemed appropriate. So, now the question is, can they get this in the trial? There's no way in hell they get this in at the trial. Not a chance. Bev will block this at the first sight that it gets pulled out. It depends how badly, whether or not Jackson's willing to fall on his sword when, say, Proctor or one of the other officers are up there and he goes, are you aware that a audit report completed by the audit team says that you did this, and this wrong, and the integrity of the investigation was compromised? The objection will be out of Brennan's mouth halfway through that sentence, but as long as he can get those words in front of the jury, it might be worth a contempt charge. Not that I would in any way ever advise that, because that would be inappropriate. And I'm going to close that blind. Ugh, there we go. So that I don't quite have the sunlight in my eye. It really sounds like they were setting the investigation up to fail until they realized they had a Pat City fall depended on. Kind of seems like that, doesn't it? Due to the blizzard conditions on the morning of January 29 and the coordination of personnel, the State Patrol waited until 4:45 p.m. to begin a secondary search of the crime scene. Each piece of evidence should have been carefully logged and tracked to establish a timeline of handling. What the hell? Officers should refrain from using personal owned phones to video and photograph crime scenes. Once evidence is processed, it should be stored in a secure and controlled environment, such as an evidence room with restricted access. If there is any doubt about legal requirements, it is essential to consult with the department's legal advisors to ensure. Oh, God, so here we go. So here's some recommendations. Increase training opportunity patrol officers and sergeants to access crime scene management training and witness interview and interrogation training. Chief Investigations Division should review all death investigation police reports and ensure all investigative avenues were completed before the reports are finalized. So basically, they need to make sure that everyone actually gets interviewed before the thing is finalized. Great. Ensure all documentation is prepared in a format that can be used as evidence in court. Oh, because, well, Your Honor, we're not going to create a document out of thin air that doesn't exist. Except for a week later when they created a document out of thin air that didn't exist. Rewrite Canton PD policy and procedure related to the utilization and authorization of personal cell phones to photograph, video, or crime scenes. All policies should be changed to require the use of only department-issued cell phones to photograph crime scenes. All sergeant patrol vehicles should be equipped with full crime scene kits, including bags, sealing equipment, and digital cameras. Department phones should be placed in patrol cars for officers to utilize to document crime scenes. Patrol officers and sergeants advise the audit team that Canton PD has one digital camera at headquarters. Wait, what? Thanks, Shuri. Prevailing law dictates that the Massachusetts State Police or the District Attorney's Office will lead death investigations, but it does not preclude the Canton PD from assisting in such investigations. It should when there's a clear conflict of interest, and frankly, Proctor shouldn't have been anywhere near this either. We know this. They recommend that Canton PD should engage and support MSP and the District Attorney's Office as deemed appropriate. Corrective action. On 31 October 2023, Chief Helena Rafferty updated the Canton PD policy and procedures related to evidence collection. References made to Canton PD Order 601. New policy includes protocols including handling crime scenes in inclement weather. New policy and procedure. Oh, for fuck's sake. Audit team verified that the department purchased crime scene kits that are now available for crime scene collection for all officers. Are you seriously telling me that Canton PD did not have enough crime scene things to go around? Yes, all the derogatory texts and stuff were on his personal phone. The audit team found no evidence supporting claims that any Canton PD officers tampered with evidence located at 34 Fairview. The audit team further found that only Canton PD officers should have been recused from the police investigation. Oh, the only officers were Kevin Albert and Chief Keeley. Fuck off. Canton PD has a full investigative authority to work in concert with District Attorney. Based on interviews and reviews of investigative reports, the audit team determined that Canton PD, as first responders, worked in the initial crime scene and conducted initial interviews of some witnesses at the scene. The audit team did find policy and procedure failures related to crime scene processing. Audit teams determined that Canton PD's internal controls and compliance oversight have improved since the initiation of the audit, and that effective leadership is in place to fuck off. I tell you what, though, I was mildly impressed that they turned around and said the use of the snowblowers was innovative. Jesus Christ. Notice of reciprocal discovery. Defendant's motion eliminating to allow evidence of lack of bias. Denied. Shocker. Well, I think that might bring me up to date in terms of the documents as well. Now I'm just going back through. I think these are some of the ones that I've already looked at. Who in the right mind would double down on this investigation? I have no clue, honestly. Morons. Where is... Jury selection. The Keystone Cops. Well, where is that? All right, Bev, what do you got?
Canton Police Department, Sergeant Yuri Buchanan from Massachusetts State Police, Shannon Burgess from South Lake, Texas, Cheryl Waugh from Canton, Sophie Herzan from the Mass State Police Crime Lab, Stephanie Devlin from the Mass State Police Crime Lab,
read through the entire
Stephen
list?
Mullaney from the Canton, Austin from Canton, from Lorton, Virginia, Ray Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty, Canton, Garino, Trooper Zachary Clark, Wendell Rober, any of those folks. So, as you can imagine, this case is expected to take a while. The lawyers tell me that once we get a jury, which may also take a while, once we get a jury, that it's estimated that the evidence in this case should take 6 to 8 weeks.
That might be the one.
We do our best to let you know in advance what we anticipate the length of trial will be. When we start the trial, we will go full days so that we can expedite the trial. The dates that I'm giving you, the 6 to 8 weeks, is the far end of what we expect this to be, just for planning purposes. So the days will begin at 9 o'clock. We'll take a recess at about 11 for 15 or 20 minutes. We'll go until 1. Lunch will be brought into you. We'll start up sometime around 2 and go till 4 o'clock. Or 4:30 every day. And there'll be days off here and there throughout the schedule, and perhaps half days throughout the schedule. So that's the schedule that we intend to keep. Now, it might help you if I give you a preview right now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the legal principles that govern the trial. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime in order to bring the trial in the superior court.
Let me give you
But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the Commonwealth, you accuse me, now you prove it, and prove it beyond a reasonable doubt. I do not have to say a word. A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably...
Oh shit, I didn't realize I was... holy crap, she's actually going to try and explain to the potential jurors what beyond reasonable doubt was? That's funny, because I'm pretty sure during the first trial, she cracked the shits when people tried to tell her how... Okay.
Pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before the jury in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. A juror's job is to find the facts. In determining the facts, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and circumstantial evidence. I'll define those terms in greater detail later, but direct evidence essentially is evidence of what a witness claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Jurors are entitled to consider both kinds of evidence. There is no difference at all in the probative value between direct and circumstantial evidence. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, I've used the word inference. An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one which is not too remote in the ordinary course of events. You may not guess, you may not speculate or engage in surmise. When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, obviously, as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely.
Holy crap, gone to the dogs dropping 5 memberships. Thank you, mate. Very much appreciate that. Seated 7 jurors so far, on average, 75% have known about the case. More to the point, I think it was yesterday or the day before, or it was day 1 or day 2, 38% of the people put their hands up saying that they'd already made a conclusion about already come to the conclusion about the case. Damn, it's actually cold in here. I'm going to put the heater on.
To all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of on unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you individually and as a group do your best to resolve this case based upon the evidence and law without sympathy, bias, or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So for jury selection, it's important to know if any of you might have doubts whether you can accept and follow these legal rules. So I'm going to ask you questions in a few minutes. So if your answer is yes to any of my questions, please raise your hand. Before we begin, though, I understand that sometimes jurors do not fill out the juror questionnaires completely, that sometimes we are in a rush to send them in, or sometimes we don't think that our situation applies to the question that is asked. If the lawyers and I notice that the questionnaire appears to be incomplete, we may ask you to answer the question for us. Also, if you know now that you failed to include information on the questionnaire, for example, a work history, prior involvement with the court, whether it's a party in a case, a witness, or a juror, please let us know. So while you're taking out your cards, I will see counsel and Chief Rosen, juror number 79 too, and counsel at sidebar, please.
I'm not going to watch the entirety of this because it's like 2 hours.
Have you had any prior dealings with any of the witnesses whose names I've read? Please raise your hand.
96, 96, 32, 32, 59, 59, 3, number 3. Number 83.
Juror number 46. Juror number 90.
All right, thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or with the Norfolk County District Attorney's Office? I see no affirmative responses. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I
Imagine
see
if
no
Bev had
affirmative
raised her hand for that.
responses. Has anyone seen, heard, or talked about this case? Please raise your hand.
Juror number 47. Juror number 108. Juror number 54. Juror number 4. Juror number 7. Juror number 95. Juror number 12. 2. Juror number 35. 5. Juror number 2. Juror number 107. 107. Juror number 41. 41. Juror number 46. 46. Juror number 24. 24. Juror number 97. 97. Juror number 23. 23. Juror number 99. 99. Juror number 25. 25. Juror number 90. 90. Juror number 92. 92. Juror number 91. 91. Juror 106. Juror number 101. Juror number 68. Juror number 65. Juror number 105. Juror number 60. Juror number 115. 115. Juror number 76. Juror number 66. Juror number 85.
Juror number 57. Juror number 6. Juror number 96. 96. Juror 109. Juror 113. 13. Juror 73. 73. Juror 31. 31. Juror 32. 32. Juror 111. 111. Juror 88. Juror 53. 53. Juror 110. Juror 59. 59. Juror 40. 40. Juror 94. 94. Juror 3. Juror 86. 86. And juror 62. 62. Juror 84. 84. Juror 112. 112. Juror 64. 64. Juror 82. 82. Juror 19. 19. Juror 77. Juror 17. 17. Juror number 75. 75. Juror number 38. Juror number 43. Juror number 29. Juror number 87. Juror number 28. Juror number 56. Juror number 113. Juror number 36. Juror number 98. Juror number 83. Juror number 72. Juror number 14. Juror number 42. Juror number 78. Juror number 18. Juror number 67. Juror number 37. Juror number 69. Juror number 63. And juror number 22.
Juror number 30. 30. Juror number 45. 45.
Okay, thank you. Have any of you folks expressed or formed any opinion with respect to this case? If so, please raise your hand.
Juror number 108. 108. Juror number 7. Juror number 95. 95. Juror number 107.
Fastest way to get yourself off the jury, though.
Juror number 2. Juror number 35. 35. Juror number 8. Juror number 97. 97. Juror number 90. 90. Juror number 91. Juror 106. Juror 101. Juror 105.
Oh, it just occurred to me. That's the new lawyer that's sitting there. The one that was juror in the first row.
115. Juror number 66. Juror number 85.
Juror 109. Juror 73. 73. Juror 86. Juror number 3. Juror 94. Juror 40. Juror 59. Juror 53. Juror 84. Juror 112. 112. Juror 64. Juror 82. Juror 77. Juror 17. 17. Juror number 75. Juror number 43. Juror number 29. Juror number 28.
Well, that's why they had to call in like 216 people, Glennis. They're not going to be able to find anyone. Honestly, this is the biggest argument for why there should have been a
Thank you. Are any of you
Thank
folks
you.
aware of any bias or prejudice that you may have in regard to this case, or in favor of or against either of the parties? If you believe that you
like half the jury just stands there and points at her. The way that she phrased it, it's just like, yes, we're aware.
might have a bias, please raise your hand.
Juror number 25, juror number 8, juror 90, juror 91, juror 101, juror 105, juror 65, juror number 60, juror number 115, 115, juror number 66, juror number 85.
Juror number 17, juror number 38, juror number 36, juror number 37, juror number 3.
All right, thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
English.
Juror number 95, juror number 8,
Juror 101, 101, juror number 65.
Only like 4 minutes left of this, and then I'll stop it. So.
Juror number 13, juror 31, 31, juror 75, juror 36, juror 98,
juror number 33, 0.
Okay. Would any of you folks have any difficulty following the concepts that I've described? First, that the burden of proof rests entirely with the Commonwealth. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She is presumed to be innocent unless and until the jury determines that the Commonwealth has proved its case beyond a reasonable doubt. Is there anyone who would have difficulty following those very important constitutional concepts?
I mean, you kind of seem to.
858, juror number 8.
Okay. Now, I can tell you folks that after every jury trial, I talk to jurors, and they often tell me not only that their jury experience was an interesting one, but a rewarding one. I do understand, though, that for a few of you, however, service in this jury may be a substantial hardship, and let me explain what I mean by that. It's something more than mere inconvenience, because every civic duty we have causes us to be inconvenienced. It's far more extraordinary. It's something that would justify your being excused and a fellow juror having to serve in your place. I do understand, though, that it may be a substantial hardship. So if anyone has a substantial hardship, and what I typically mean by this is you have airline tickets or surgery scheduled during the course of this trial. But bearing in mind that this case may take 6 to 8 weeks to try according to the schedule that I've described, and keep in mind that I'll only excuse those who have a substantial hardship. If you think you are in that group, please raise your hand.
Juror number 97, 97, juror number 47, 47, juror 108, 108, juror number 8, juror number 50, juror number 7, juror number 23, 23, juror number 24, 24.
Juror number 90, juror number 91, 106, 101, 34, 105, 70, 80, 60.
Juror 6, juror 109, 13, 31, 32, 88, 53, 110, 3, 112, 64, 82, 17, 17. Juror number 43, juror number 42, juror number 69, juror number 63. Juror number 62, 62.
Juror number 41, 41.
All right. So in a few minutes, I'm going to leave the bench to give you a chance to fill out the supplemental questionnaires that we have. I ask that you not talk to anyone around you or share with any other prospective juror or anyone any questions or comments or concerns that you may have about jury duty, either generally or in this particular case. if you should have any questions or concerns, you can raise that when you come back to talk to me. So we appreciate your patience. We understand that this will take a while. But I will recess now for you to do that. All right. Thank you.
See you, Chris. Oh, all right. So for those of you, I'm gonna stop that there because let's face it, jury selection is never particularly interesting. Even when you're the attorney sitting at the desk and you're having to keep track and who you're going to strike the call and who you can potentially use a peremptory challenge against and that sort of thing. But of something far more interesting to me, because I saw this earlier today. Don't know how many of you may or may not have seen it, but Mark Randazza, who you may or may not know from certain other recent things that we're not going to talk about, he has lodged a complaint and is suing Bev as well as the district attorney's office. It'd be hard to be a jury member in this case because you'll have 6 to 8 weeks of bullshit from cops, pretty much. So this is jury selection isn't interesting for the jurors either. No. So verified complaint. This one's federal because it's a First Amendment action. The Karen Read trial has drawn significant public attention. Plaintiffs are members of the public who wish to publicly express themselves near but not on the grounds of the courthouse where the second Karen Read trial is taking place. Their primary concern is that they wish to criticize Judge Canone. Corrupt Canone, corrupt Cannoni, corrupt cannoli, off cannoli, sour cannoli. They've been doing so since November 2024 without incident. They have been doing so peacefully. They've been doing so while Judge Canone presides over cases at the Dedham Courthouse, and neither the Sixth Amendment nor the First Amendment have felt the slightest chafe. However, Judge Canone has found her pretext to shut down protests against her, an ignoble request from the Commonwealth that an ill-defined buffer zone be declared on the streets, public walkways, public library, and private property surrounding the courthouse. Judge Canone joyfully entered the order ex parte, enjoining the plaintiffs and everyone else who are not subject to her jurisdiction from speaking on private property and on traditional public fora. You could have just said in public forums. Jesus. It is a lawless ultra vires act that violates the constitutional guarantees of free speech and a due process. Canone has issued this order primarily to quash criticism directed at her. I'm going to continue to criticize her ass any which way I like. I don't even have to get close to the courthouse to do so. As this the only protests that have been documented have been the plaintiffs in this case, who have quietly held signs criticizing Canone. To remedy this constitutional wrong, the plaintiffs Jason Grant, Alison Taggart, Lisa Peterson, and Samantha Lyons bring this civil action against the defendants, being the trial court of the Commonwealth of Massachusetts, Beverly J. Canone, in her official capacity as a Justice of the Superior Court, Jeffrey Noble, the Superintendent of the Massachusetts State Police, and Michael de Etremont, in his official capacity as Chief of the Police Department of the town of Desmond, Massachusetts, and Michael W. Morrissey in his official capacity as Norfolk District Attorney. Plaintiff brings the claim under Title 42, Section 1983, for defendants' violation of their First and 14th Amendment rights. I'm not going to bother with the parties. That is pretty much what it bears down to. Stop making fun of me and pointing at my corrupt bullshit. Yes. Imagine that, both held to account. And it took the federal court, surprise, surprise, to do it. And now that we know that the federal investigation is still ongoing as well, I think she's going to learn the hard way that she really should have stayed this fucking case. Jurisdiction and venue. On or about January 29, 2022, John O'Keefe, a Boston police officer, died. On or about June 9, 2022, a true bill was returned to the trial court of the Commonwealth of Massachusetts Superior Court Department, Norfolk County, indicting Karen Read and charged her with second-degree murder, killing O'Keefe with a motor vehicle while intoxicated, and a hit-and-run death. Defendant Canone is the presiding judge in the Read prosecution, in this case styled Commonwealth v. Read, in the trial court of the Commonwealth of Massachusetts. Norfolk County District Attorney's Office, led by Michael Morrissey, is prosecuting the Read case on behalf of the Commonwealth. A trial in the Read case was held in 2024, which resulted in a mistrial after the jury failed to reach a unanimous decision. The second trial for the Read case began on April 1. Prior to the first trial, the Commonwealth had filed a motion to inter alia create, amongst other things, create a buffer zone beyond the grounds of the Norfolk Superior Courthouse to prohibit any individual from demonstrating in any matter about Reed, law enforcement, the DA, potential witnesses, and evidence within 500 feet of the court complex during the trial. Massachusetts citizens Tracy Ann Spicuza, Lorena Jenkinson, Dana Stewart Leonard, and Paul Cristoforo thereupon moved to intervene for the limited purpose of opposing the buffer zone. Motion to intervene was denied by Judge Canone, who declared that the citizens had no right to intervene, even though the order would directly affect them. Judge Canone then issued an order granting the Commonwealth's motion, asserting that the Commonwealth's perceived inconveniences overcame everyone else's First Amendment rights without regard for any differentiation between members of the public, and expressly ordered that no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the court complex during the trial, unless otherwise ordered by the court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Register of Deeds building. Individuals are also prohibited from using audio-enhancing devices while protesting. That's pretty much it, Bush. She's in trouble. Speech that does not qualify as a demonstration was not restricted. Thus, a nearby cafe could advertise breakfast using a bullhorn and parade its menu on picket signs and placards. Celtics, and Bruins fans could similarly honor their teams by hootering and hollering and carrying placards. And in fact, commercial speech was permitted within the zone. In advance of the second trial, the Commonwealth again moved for a buffer zone, but with a larger area, again encompassing private property and traditional public areas, including public sidewalks and other areas. The Commonwealth also sought specific instructions to request the police use force to quash any dissent or protest. And if what Sheree's mentioned has anything to go on, apparently the cops are getting a little bit heavy-handed in enforcing that too. Without an opportunity for affected persons to intervene or be heard, Judge Canone issued an order on March 25, 2025, granting the Commonwealth's motion, asserting that the basis for the first motion warranted a larger buffer zone for the second trial, and expressly ordered that no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the court complex during the trial, unless otherwise ordered by the court. This complex includes the Norfolk Superior Courthouse building and the parking area. The buffer zone shall be further extended to include the area bounded by Bates Court, Bullard Street, Ames Street, and Court Street. Individuals are also prohibited from using audio-enhancing devices while protesting. That's like 500 feet, is my understanding. For the past several months, plaintiffs have been engaged in peaceful demonstrations with no adverse incidents. Such demonstrations took place in the location that is within the buffer zone of the second prior restraint order. For example, plaintiff Jason Grant peacefully demonstrated on the sidewalk next to the courthouse, holding signs that read, "Judge Bev is conflicted, and Bev's court is a clown show," regarding and with images of D.A. Morris and Judge Canone. Such demonstrations were specifically about Judge Canone and occurred during trials presided over by Judge Canone. There were no disturbances, incidents, or interferences with any of the trials taking place, but Judge Canone was apparently embarrassed and annoyed by people protesting against her. Nevertheless, nobody's rights were impeded upon, and not one complaint was received that the plaintiffs are aware of. Oh, look, if Adrian showed up here, I would happily take him for a beer. We know this. Plaintiffs wish to continue to demonstrate, including criticizing Judge Canone off the grounds of the said courthouse complex, but within the buffer zone during the second trial. Plaintiffs reasonably fear that Judge Canone will attempt to hold them in contempt if they engage in such demonstration, or will otherwise attempt another unconstitutional act to suppress those who would criticize her publicly. Plaintiffs reasonably fear that the Norfolk County District Attorney's Office, under control and direction of Morrissey, will seek their prosecution for violation of the order should they engage in demonstration. As Dedham police officers took action to enforce the buffer zone order during the first trial, plaintiffs reasonably fear that the Dedham Police Department, under the control and direction of the defendant, will arrest them for violation of the second prior restraint order if they engage in such demonstration. As Massachusetts State Police officers took action to enforce the buffer zone, the plaintiffs reasonably fear that Massachusetts State Police, under the direction of Noble, will arrest them for violation. Violation of the First Amendment of the United States Constitution, declaratory judgment, and injunctive relief. The second prior restraint order is facially unconstitutional, and it is content-based regulation of protected speech in a public forum that cannot withstand strict scrutiny. While the Supreme Court has upheld a statute relating to picketing operating near courthouses, it has not approved a 200-foot buffer with an additional larger ill-defined area. It is over-inclusive, and it includes speech in private businesses and homes in traditional public areas. It is therefore under-inclusive, it is under-inclusive as it does not regulate other forms of speech directed at potential jurors, the ostensible fair trial reason given. I did see that, Mark, and I actually read through that. I think that a lot of them has been people that are upset over the Reid case. Seeing that there were 7 reviews from practicing attorneys that were very critical of her, you know what? We might actually go and have a look at that in a minute. The second prior restraint order purports to address noise and to minimize prospective jurors' exposure to viewpoints about the Reid case, but it is targeted solely to speech in the ambit of the Reid case, where Judge Canone and Superior Court routinely conduct jury trials without such restrictions. Judge Canone could have taken measures to reduce jurors' exposure to noise and public speech without imposing content-based restrictions. The second prior restraint order is unconstitutionally vague. Plaintiffs cannot ascertain where they may not demonstrate, as the purported bounds are not bounds at all. Plaintiffs cannot ascertain exactly where the speech is prohibited. It is unclear if they can wave political signs that say vote against D.A. Morrissey or Judge Canone is corrupt. The second prior restraint order is an unconstitutional prior restraint on speech. It is unconstitutional as applied. The defendants have been purposely targeting people like plaintiffs who dislike Judge Canone, and there is nothing that suggests that they would threaten anyone siding with the prosecution or supporting Judge Canone. Plaintiffs have been injured or reasonably fear imminent injury by these constitutional violations, and the plaintiffs are entitled to relief. A fucking man. Violation of the 14th Amendment. The defendant's conduct of issuing and enforcing the second prior restraint order is unconstitutional and violates the right to due process under the 14th Amendment. Prior to being deprived of their rights to speak freely and assemble, the plaintiffs were entitled to due process. Excuse me. There was no hearing, no opportunity to be heard, nor was there any due process whatsoever. There was merely an arbitrary and capricious action designed to harm the plaintiffs and others, issued by one person on account of anticipated First Amendment protected activity. Judge Canone's second prior restraint order was issued in the absence of statutory authority or inherent authority over persons not brought within her jurisdiction through process. Judge Canone's second prior restraint order was a usurpation of legislative and regulatory function that is not a judicial act. Judge Canone has no authority over what non-parties to a proceeding may or may not do off courthouse property, let alone on private property or in traditional public forums. The Massachusetts Constitution does not empower the Superior Court justices with explicit or inherent authority to regulate private property or traditional public areas in the way that they might regulate courthouse property. No Massachusetts statute empowers Superior Court justices with explicit or inherent authority to regulate private property or public flora in the way that might regulate courthouse property. No ordinance does the same thing. I'm not going to reread that because I keep stumbling over the words. The plaintiffs have been injured or reasonably fear imminent injury by these constitutional violations, and the plaintiff is entitled to relief. Therefore, plaintiffs are entitled to a declaration that the second prior restraint order is unconstitutional. Tell you what, I will give you said declaration right now. I declare, as the Aussie Overlaw'd, that is completely and insanely unconstitutional, and I'm looking forward to this one being overruled. You watch. Just because I've said that, they'll come back when they actually hear and go, nah, she's fine. Therefore, plaintiffs are entitled to a declaration that's unconstitutional and entitled to an injunction on the prior restraint order's enforcement. They're looking for 2 declarations, preliminary and permanent injunction to award plaintiff reasonable attorney's fees and such other relief as the court deems fit. Signed, Mark Rendaza. So like I said, I didn't see this one coming, but man, I am all for it. I really am. Let's have a look. So that's been... Just trying to see if I can find the images of the protest. Unfortunately, this video is not available in your region. Fuck you.
Good morning, Liz Bateson here. I am in Dedham, Massachusetts right now, covering the murder trial of Karen Reed. It is day one of the trial. Jury selection is currently underway. You can probably hear a lot of noise behind me. That's what this case has garnered a lot of attention. Just to give you some background for anyone not familiar with the case, Karen Reed is charged in the murder of her boyfriend, Boston police officer John O'Keefe. She's accused of running him over with her SUV back in 2022 and then leaving him out to die in a snowstorm. She says she's innocent and that she's actually being framed by law enforcement. So the case has garnered a lot of attention, a lot of protests and debates over this. I'll flip the camera around and give you a look. You can actually see people outside of the courthouse now with signs saying "Free Karen Reed," in support of Karen Reed. They've been out here all morning since jury selection got underway around 9 this morning. And they're actually 200 feet away from the courthouse. So the courthouse is down that way. The judge ordered that they have to stand 200 feet away from the courthouse, kind of creating this buffer zone because of all of the attention that this case has garnered. Anyone that is wearing shirts that say "Free Karen Reed" or in support of either party aren't allowed within 200 feet of the courthouse. You can see the cone set up and there's this buffer zone where the courthouse is. So jury selection is currently underway. I've been out here all morning where these protesters are. I'll have a live report at noon with the latest updates as this trial gets underway. So be sure to tune in then.
So I ducked over to the road just to try. I cannot believe this, but in Massachusetts, she's not even in the bottom 10 judges. Like that still shocks me. I'm not gonna lie. Oh, hang on. Latest comments. Criminal defense attorney on the 2nd of April at 10:55 p.m. This judge is corrupt as they come. Damn. Anyway, all right, so let's go to Norfolk County. She's got 44 reviews. Most of the judges have 0. This other guy, Paul Yee, I'm curious. I want to have a look at him in a second. But she's got an average rating out of 44 reviews of 2.3. Now, like I said, like 30-odd of these we need to ignore because, you know, I think a good number of these are just people that are pissed off about the Karen Reed trial that aren't actually like attached to the case, shall we say? Which, you know, you can do what you want, but this is the same as review bombing Dr. Spiegel in the Johnny Depp Amber Heard trial. Like, just because she deserves it doesn't mean you should do it. Damn. Average attorney rating is 2.3. Oh, there's now 13. There's 13 ratings by attorneys, and non-attorneys, she's got a 1.0. That's funny. So we got judge is corrupt as they come. Judge bears a singular responsibility for the length of the first trial, short days, no days, etc., and continues with their treatment of the defense and their ability to mount a defense. Just like Proctor wished Karen Reed would commit self-yeeting, Judge is bringing her into bankruptcy. She's also so obvious as to her bias. Yeah, we all get that. Review bombing can end up hiding actual bad reviews if they just do a clean slate and remove all the reviews. This is true. What do we got? Viewing the Karen Reid trial from Iowa. So again, so you know what? Not going to say it. But keyboard warriors, we probably shouldn't be doing this because it does have a overview. Oh, hang on. I forgot about this. At one point, there were over 100 and something reviews, and then the roving room had to go through and remove a whole bunch of them. Sites intended for members of the bar and the public to provide honest commentary, critique, and praise of judges. While we do not act as gatekeepers, pre-selecting the comments for publication at the same time, we periodically review comments and remove them when inappropriate or potentially libelous. Examples of inappropriate commentary include calling a judge corrupt, on the take, drunk, or a criminal. Well, it's funny because you've got a criminal attorney that literally just called her corrupt, but okay. Same to flaming the judge with the identical criticism minute after minute, day after day is also inappropriate. Of course, divulging personal, non-public information about a judge, their family, blah, blah. Yeah, okay, fine. Here's another criminal defense lawyer. Judge Beverly Cannoni's handling of the Karen Reid trial continues to raise serious concerns about the fairness and judicial integrity. Her courtroom decisions consistently favor the prosecution, creating a one-sided trial that undermines the very concept of due process. From the outset, she's demonstrated a troubled pattern of suppressing defense arguments, disregarding key evidence, and allowing blatant misconduct by the prosecution to go unchecked. One of the most alarming aspects of her conduct is refusal to allow critically exculpatory evidence that contradicts the state's narrative. She's actively blocked expert testimony and crucial witness statements that exonerate Reid, while permitting the prosecution to present speculative and questionable evidence. This is selective gatekeeping, which suggests an agenda rather than an impartial application of the law. Her bias extends beyond rulings. It's evidence in her demeanor and her control of the courtroom. She frequently interrupts Reid's defense team, cutting off their arguments and diminishing their ability to challenge the prosecution's case. Meanwhile, she grants the prosecution wide latitude, allowing them to make misleading claims and objections without scrutiny. The double standard is impossible to ignore. Furthermore, she's allowed law enforcement figures involved in the case to escape scrutiny, even after the face of clear evidence. Even in the face of clear evidence of investigative corruption. Rather than ensuring a fair trial, she appears to be protecting those with institutional power at the expense of the defendant facing life-altering consequences. The trial should have been about uncovering the truth, but under Cannoni's oversight, it has become a mockery of justice. Her actions erode public trust in the legal system and demonstrate why judicial oversight is desperately needed. A judge who cannot uphold the principles of impartiality and fairness has no place on the bench. Fucking well said. Oh, someone got pissy. Someone had their comment deleted and then got pissy. Next criminal defense attorney. Oh, wow. Someone actually stepped in and said, excellent judge generally, if anything, she faces the defense, but great temperament. How bad do the other ratings have to be to go from a 9.1 to a 2.3? At this point, I'm only really interested in the ones that the attorneys are posting. Deleting these factual reviews. If Judge Beverly Cannon wishes to have good reviews, she should be ethical. Damn! Extremely pro-prosecution with a blatant disregard for fairness and defendant's rights. If she has an agenda, the constitutional rights be damned. Wow, that is an extremely detailed review. Good on you. It's ridiculous that the public cannot trust this website that rates judges to be honest. Pre-trial issues and questionable rulings, bias towards prosecution, courtroom conduct, and procedural concerns. Okay, here we go. Oh, damn. This is an even longer one, and it's here for a reason. Do not erase any portion of this review. Judge Beverly Cannon's conduct raises serious ethical concerns. She's repeatedly demonstrated conduct that violates key judicial canons meant to ensure fairness, impartiality, and integrity in the courtroom. Her handling of cases suggests the pattern of bias, lack of transparency, and failure to uphold the basic tenets of judicial ethics. A judge must ensure public confidence in the integrity of the judiciary. However, her rulings and courtroom behaviour have led to widespread complaints, raising serious concern about her ability to remain neutral and fair. Rather than maintaining impartiality, she has demonstrated favouritism in cases, often disregarding evidence or silencing parties who challenge her authority. This fosters the perception that the justice in a courtroom is not applied equally. This individual is not talking specifically about the Reid case. This is someone that is talking from personal experience based on the wording here. Fuck. Judge Canone has failed to provide fair hearings, frequently interrupting litigants and making decisions that seem predetermined rather than based on case law and facts. Reports suggest that she disregards due process and essential judicial responsibility. The public has raised concern about potential conflict of interest in cases she presides over, further eroding trust in her ability to make unbiased rulings. Her reputation amongst litigants, attorneys, and even colleagues has suffered due to these repeated ethical lapses. Judicial accountability is essential, and the overwhelming number of complaints against her should not be ignored. Judges should be held to the highest standard, and when they fail, they should be called out and investigated. If you've had a negative experience in her courtroom, I encourage you to document it and file a formal complaint. Judicial integrity must be preserved, and judges like Beverly Canone must be held to account for failing to uphold their sworn duties. God damn. Following the Karen Reid case. Okay, I think we might be coming to the end of the attorney comments. As an attorney, I expect judges to uphold the principles of due process, fairness, and impartiality. Unfortunately, Judge Beverly Canone has repeatedly demonstrated a concerning pattern of judicial misconduct that raises serious questions about her ability to preside over cases objectively. In my experience, she has exhibited clear bias in her rulings, disregarded critical evidence, and shown a willingness to suppress testimony that does not align with her apparent predisposition. Rather than applying the law consistently, she appears to favour certain parties, creating an uneven playing field for litigants. Moreover, her management of the courtroom is often arbitrary and unpredictable, making it extremely difficult for attorneys to advocate effectively for their clients. The number of complaints against her is not surprising, as her judicial temperament and rulings frequently fall short of the standard expected of fair and impartial jurists. For attorneys handling cases before Judge Canone, I strongly advise meticulous preparation and vigilance, as procedural fairness may not be guaranteed. Litigants deserve better, and the legal community should not overlook the growing concerns regarding her judicial performance. Starting to notice a pattern in the reviews. I assume Bev's aware of this website. Probably. See, the scary thing is, guys, you got to remember as well. Do we honestly think she's going to retire after the Reid case? I mean, there was an argument saying that she was supposed to be and that she was holding on just to finish this case. But do we honestly think that someone like her is going to give away that kind of power? Or do you think she's just going to try and step away with no consequences? God damn. What ways her bias leaned in the past? From the sounds of the reviews, in favour of the prosecution, which doesn't surprise me if she's supposedly friends with Morrissey. She denied her own order asking her to recuse, knowing the public was already claiming she was connected. It was further proven to be true. The judge requested this case. That should tell you everything. She has a plan, and it's to help convict an innocent woman to protect the guilty ones in that house. Every single criminal defense lawyer should show up to that courtroom and send a clear message to this disgusting judge. We cannot allow a judge to reward prosecutor and police misconduct or punishing the defense and defendant for even a minuscule of an issue. It's absurd, and if it continues, this judge giving qualified immunity, judicial immunity, then I would suggest everyone leave the rogue state. Latest news, Nicola Gobo's moving to Canton where she can practice law without question. Okay, for those of you that don't know why that's funny, Nicola Gobo, lawyer X, was the barrister that was informing on her own clients to the police. And I believe that one of the major players in that area, Tony Mockbell, I'm pretty sure he was up to have his sentence reviewed yesterday as a result of what she did. Doesn't overlooking due process rights potentially open her up to past rulings for review? If I were a party that had lost in one of her cases, I would certainly be bringing it for. I mean, you've got to do certain appeals and certain reviews within time limits. I don't know the specific rules, so I'm talking out my arse here. Don't take this as any sort of authority, okay? But with judicial misconduct and procedural fairness out the window on that, I would say you'd at least try and have it reheard. Mockbell's review is pending? Okay. I love that someone used the website to file a formal complaint. Holy crap. 15 points, including facilitating a cover-up. Oh, I was wrong. We still have more defense attorney ones. As a defense attorney, I've had the opportunity to observe and interact with numerous judges throughout my career. Unfortunately, Judge Beverly Canone's handling of cases raises serious concerns regarding due process, judicial impartiality, and defendants' rights. Yeah, so she well and truly swings towards the fences for the prosecution. Judge Canone has demonstrated a pattern of rulings that disproportionately favor the prosecution, often restricting the defense's ability to present key evidence, cross-examine witnesses effectively, or argue prequel motions. This imbalance directly undermines the adversarial process, which it does, which is essential for a fair trial. The role of the judge is to act as an impartial arbiter, yet too often her decisions appear to align with prosecution's interests at the expense of the accused's constitutional rights. Additionally, her courtroom demeanor has been described as dismissive and unapproachable, particularly towards defense counsel advocating for their clients. Well, we've seen that firsthand, haven't we? A fair legal system requires judges who are willing to listen to all parties, apply the law without bias, and ensure that justice is not only served, but seen to be served. When judges fail to uphold those principles, it damages the public trust in the judiciary and jeopardizes the rights of those who rely on the courts for a fair trial. Based on my experiences and those of my colleagues, I believe that a formal review of Judge Canone's judicial conduct is necessary to ensure that the rights of defendants are not being systematically eroded in her courtroom. I doubt that this website would do anything. This is more like Glassdoor. This is more like Rate My Teacher. No, maybe not. Oh, not a lawyer, but as a court staff member in another jurisdiction, I've had the opportunity to observe and compare the practices of various judges, including Judge Canone. Unfortunately, her handling of cases raises serious concerns about judicial integrity, courtroom management, and adherence to due process. She's developed a reputation for rulings that appear to favor the prosecution at the expense of balanced legal process. Numerous reports suggest that she routinely limits the defense's ability to present key evidence or question witnesses effectively. Such practices undermine the fairness of that our legal system is built upon. Additionally, accounts from litigants and attorneys indicate that her judicial temperament is inconsistent with the standards expected of a fair and impartial judge. Courtroom proceedings under her oversight have been described as hostile or dismissive, particularly towards individuals who challenge her rulings or seek accountability. A judge's duty is to ensure that the justice is administered fairly and without bias. When judicial conduct repeatedly falls short of these principles, it damages public trust in the courts. Based on observations and widespread concerns, a formal review of Judge Canone's courtroom practices may be necessary to restore confidence in the judicial process. Oh, and then we've got two criminal defense lawyers. We got one that says one of the best judges on the bench. I'm curious. I'm going to review the details on that. As a legal practitioner, I've had the opportunity to observe Judge Beverly Canone's courtroom conduct and judicial decision-making. Unfortunately, I have significant concerns regarding her ability to uphold the principles of impartiality, due process, and judicial integrity. She's demonstrated a pattern of rulings that raise questions about her adherence to the fundamental legal standards. In high-profile cases, she's exhibited deference to prosecutorial arguments while limiting the defense's ability to present a full and fair case. This imbalance undermines the adversarial process and erodes public confidence in judicial neutrality. Additionally, reports from colleagues and litigants suggest that Judge Cohn's courtroom demeanor can be dismissive, particularly towards individuals who challenge her rulings or seek accountability. Notice how it's all the same style of language. Judges' role is to ensure fairness, not to impose undue restrictions that hinder the pursuit of justice. The legal community relies on judges who apply law consistently, free from external influence or personal bias. When judicial conduct repeatedly falls short of these expectations, it is imperative to call attention to such concerns. Based on observed proceedings and documented complaints, I believe a review of Judge Cohn's performance is warranted to ensure that the justice is not compromised in her courtroom. And we're actually at the bottom of the page there. Holy smokes. Bloody hell. So there you have it, peeps. That's what members of the bar tend to think about her. Kind of shocking it's all the same types of complaints and then a 10-star review with no words or context. Oh, well, I mean, let's face it. That one probably came from Morrissey's office. Literally, that one 10-star thing, temperament, 10. Scholarship, 10. Individual, 10. Competency, 10. Punctuality, 10. Flexibility, 10. I call it crock of shit. Pre-trial matters, 10. Trial judge, 10. Industriousness, 10. I call crap on that. I really do. I call bullshit. So, all right, folks. It is now 7 o'clock. I need to go and get some dinner because it's a small country town. Everything closes at 8. So if I want to eat, I need to eat soon. I may be back later, but otherwise I might just sit and do some video editing. Is it from Bev? It could well be. But as always, please remember, you're not a piece of shit. You have value and do contribute to society, especially for being here. Thank you for what's that I mean now? I'm still in Victoria. I'm just out in the bush. So, anyway, stay healthy, wealthy, and wise, people, and I will catch you all. Oh, excuse me. Sorry, that was rude. Later.
And again, on your way out, please do me the favor and hit the like and subscribe button if you're so inclined. It costs nothing. It's absolutely free, and we'll be friends forever. Bye now.
Unfortunately, some members of the media use their platforms
to push their own personal bias. And agenda to control exactly what people think. This is extremely dangerous to our democracy.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.